Okay, class, good evening. Tonight, we are going to continue our lecture series for the semifinals. Tonight, we are going to discuss the second PowerPoint presentation for the semifinals. We will discuss patents, trademarks, service names, and trade names. But before continuing, we are very thankful. I am going to acknowledge the people who are giving me assistance by their research so that this PowerPoint presentation will come out. Not to mention Viarde, Divi Cometa, Daisy Derigay, Kayla Marie Deniega, Judivine Disipulo, Hannah Tricia de la Cruz, and Pichi Dayaday. Now, as a matter of practice, we give pre-test and post-test examination questions. Here are the questions. Number 1, name at least one function of a trademark. Number 2, it refers to any technical solution of a problem in any field of human activity. What is it? Number 3, it refers to the right that is acquired from time of application. What is it? And then, question number 4, it is any visible sign capable of distinguishing goods or services. Number 5 question, how are marks acquired? Number 5 question, give an example of marks that cannot be registered. Number 7, give at least one purpose of patent law. Number 8, name one person that is entitled to a right to patent. Number 9, how long is a patent term? Number 10, it is the name or designation which identifies an enterprise. What is it? Now, let's answer these questions. Number 1, give at least one function of a trademark. The answer is to guarantee the standard of quality of the goods. Number 2, it refers to any technical solution of a problem in any field of human activity. It is called patent. Number 3, it refers to the right that is acquired from the time of application. Answer is the date of filing an application. Number 4, it is any visible sign that is capable of distinguishing goods or services. It's called trademark. And number 5, how are marks acquired? The rights in a mark shall be acquired through registration with IPO. And then number 6, give an example of marks that cannot be registered. Answer, immoral, deceptive, and scandalous matters cannot be registered. Number 7, give at least one purpose of patent law, your paragraph text. Okay. Answer, patent law seeks to foster and reward invention. Number 8, name one person that is entitled to a right of patent. Number 1, inventor, his ears, and a sign. How long is a patent term? 20 years from the filing date of application. Number 10, it is the name or designation identifying an enterprise. It is called trade name. Now, let us discuss further. Now, what are patents? Patents refers to any technological solution of a problem in any field of human activity. That is patent. Now, what is the purpose or what are the purpose of patent law? 1, patent law seeks to foster and reward invention. Number 2, it promotes disclosures of invention to stimulate further innovation and to permit the public to practice the invention once the patent expires. Number 3, the stringent requirement for patent protection seeks to ensure that ideas in the public domain remain there for free use of the public. And denote the classes of patentable inventions. 1. Useful name. 2. Product. Then process. Then improvement. A. Microorganisms and non-biological and microbiological processes. Who are the persons that are entitled to the right to patent? 1. The right to a patent belongs to the inventor, his heirs, and assigns. B. 2 or more persons that have jointly made an invention. And the first to file rule is the right to a patent shall belong to the first person who filed an application for invention. What are the limitations of patent right? A. Owner's consent. Using a patented product which has been put on the market in the Philippines by the owner of the product. What else? Parallel importation, which means importation of drugs and medicines by any private party. C. Non-commercial. Acts done privately and non-commercial scale. E. Experimental use. The act consists of using exclusively for experiment use for scientific purposes or educational purposes. Terms of a patent. The term of the patent is 20 years from the filing of the date of case. Now, what is a trademark? Trademark is any visible sign that is capable of distinguishing goods or services. What is a trade name? A trade name or designation is a name or a designation identifying an enterprise. What is a collective mark? A collective mark is any visible sign designated as such in the application for registration and capable of distinguishing the origin or any common characteristics. Now, functions. Let us go to functions. What are the functions? To indicate the origin of goods to which they are attached. B. To guarantee the standard of quality of the goods. And C. To advertise the goods. It's case in Mepori versus Court of Appeal. Now, how are marks acquired? A. The rights in a mark shall be acquired through registration with the Intellectual Property Office, as can you confirm in Section 122 of the International Intellectual Property Code. Registration is necessary before one can file an action in an infringement, and there must be an actual use. Now, prior use in the Philippines is not required before registration. It was asked in the 1985 bar. There must be an actual use after registration. The registrant shall file a declaration of actual use of the mark with evidence that the effect within 3 years, otherwise it may be cancelled. 3. Certificate of registration of a mark shall be prima facie evidence of the registration. Registration is also not important to protect the goodwill that identifies in the mind of the public the goods he manufactures or deals in. Registration of mark is not necessary for purposes of filing a case of unfair competition or false designation of origin. Sections 168.2 and 169 of the Intellectual Property Code. Now, what are those marks that cannot be registered? 1. Immoral, deceptive, or scandalous marks, or scandalous matter. Another, one that consists of the flag or coat of arms or other insignia of the Philippines. What else? One that consists of a name, portrait, or signature identifying a particular living individual except by his writing consent. D. Identical with a registered mark belonging to a different proprietor. Those are the marks that cannot be registered. Now, what are the limitations? Doctrine of secondary meaning. This is a generic descriptive mark that acquires the character of distinctiveness if it acquired a meaning which is different from its ordinary connotation. Then, composite marks. Colors and shapes may be part of the composite mark, although it cannot register as generic or descriptive. Another limitation is coined and coined marks. Contained or coined marks. These are marks that can be registered even if they are coined from generic or deceptive terms. Now, what do we understand by arbitrary use. It is generic and descriptive terms may also be registered if they are used in an arbitrary or fanciful manner. Now, rights conferred. When you are given a patent, one, the right to exclusive use of the mark for one's own goods or services. What else? Right to prevent others from the use of the same mark. And lastly, the right to the exclusive use of already registered mark even for goods or services into one's venture. Now, duration. The duration of the mark is 10 years subject to indefinite renewal for periods of 10 years each. What do you understand by infringement? Infringement is a violation, a breach, or an authorized act. It is the meaning of infringement. Now, protection of trade name. A trade name need not be registered with the IPO before an infringement suit may be filed by its owner against the owner of an infringing trademark. And those are the distinctive features in the study of marks, trade names, etc. So, thank you for listening, and I hope you can answer in the semi-final because the questions which I will be taking will be coming from these PowerPoints. So thank you and good evening.